Hello, my name is Paul King, and I'm a district court judge in Douglas County, Colorado. With me today are fellow panel members District Court Judge Mary Dagenhart from the 7th Judicial District and Chief Judge Mick O'Hara from the 14th Judicial District. We're going to engage in an informal discussion of the taking of guilty pleas. I have a few brief introductory remarks to make before we begin our discussion. Statistics show that more than 90% of criminal cases resolve without a trial. Therefore, you will preside over the entry of many guilty pleas. It is important that you develop your own consistent approach to the taking of pleas. For your consideration, pages 120 to 124 of the Colorado Judicial Welcome Packet contain an example of an advisement at the time a plea is being taken. Each judge must decide for themselves what procedures and practices they will adopt for the taking of a guilty plea. Do you have a deadline for the taking of pleas? For example, will you take a plea only at a scheduled event, or will you take a plea up through a motions hearing, status conference, or the start of trial? Will you accept a sentence stipulation to a certain sentence or a sentencing range? Will you proceed to immediate sentencing if the parties request and if the sentence is stipulated? Do you require the defendant to stand during the taking of the plea? These are some of the matters you should consider in developing your approach to the taking of a guilty plea. What follows is a general discussion between the three of us on various topics that involve the taking of a plea.
How do you handle the paperwork involved in the taking of a plea? By this I mean the motion to add or amend counts, the motion to dismiss counts, a plea agreement form reflecting the nature of the disposition, a deferred judgment and sentence, request to plead guilty form that covers the rights of the defendant. How do you handle that paperwork, Judge Dagenhart?
I normally have the parties have already prepared the paperwork when they come to court, and they present it to me. They recite the terms on the record, and then I gather up the paperwork. I have found recently that I need to really pay attention to what they're providing me, because twice in the last week or so I've had them recite terms on the record, and then the paperwork they handed in was different and said very different things than what they had on the record. So,
Judge O'Hara?
Well, as Judge Dagenhart said, some of the trick is to get to the point where you can work well with your district attorney's office. And once you can trust them to do the paperwork correctly, in my practice, I make them do the Rule 11 advisements in writing, and I include that as part of the file.
And that's what I do too. I let them give that to me, but then after they say the disposition, I always look to make certain the paperwork fits with what they've just told me in court. Do you go over verbally with each defendant certain rights that are being waived, Judge Dagenhart?
I do. I try to go through actually almost everything that's in the Rule 11, everything that's in the actual Rule 11, and then there's more. But yes, I go over all of that with them.
Judge O'Hara?
I do the same thing. If I am in a situation where multiple defendants are going to be entering pleas in a given day, I'd tell them all in advance to pay close attention, and I'd go through it once.
That's good. I usually go through like 4 or 5 things, the right to a jury trial, the right to call witnesses, cross-examine, and to require the people to prove the charges beyond a reasonable doubt. But then I usually don't go much past that, figuring that they've got it covered in their written paperwork, hopefully. Do you advise each defendant of the potential sentence?
I do that as well, just because they may come back and they should know what the potential sentence is. If I happen to reject a plea, then they also should know what the potential sentence is. So yes, I always do that.
Judge O'Hara?
As we know, sometimes they're a little bit of a deer in the headlights. So even though it's in writing, they may not be picking it all up. So I think it's really important to hit those big highlights, like what can happen if you violate probation in the future.
And I usually tell them what the sentencing potential range is too. Just like you said, they have that deer in the headlight look, and you want to make sure it's kind of covered. Do you take stipulated sentences, Judge Dagenhart?
I do that as well. That's pretty typical with a lot, especially one of the counties that I've been working in. A lot of the plea agreements do have stipulated concessions, but it kind of depends on what it is. Depending upon the charges and what they've stipulated to, I may or may not. But ordinarily, I almost always will take their stipulated sentence if it seems reasonable.
I did a lot of criminal defense work in my prior life, and I just really believe, even though not all of our colleagues do, that a stipulated sentence or sentencing concessions that are binding on a judge are really an important part of the process. So I have personally chosen to do that.
And I do too. I figure that the lawyers probably know a little bit more about the case than I do, and if they've agreed on something, I'm willing to take that typically. If you do that, though, do you still advise of potential sentences, Judge Degenhardt?
And again, I think for the same reasons that Judge O'Hara indicated, just in case it comes back, just covering all the bases, I think it's important to do that.
Judge O'Hara?
Or when it comes back, as some of my more cynical colleagues might say.
If there's a stipulated sentence in the aggravated range, do you advise the defendant of that, talk about waiving his right to a jury with respect to the aggravated sentence? How do you do that, Judge Degenhardt?
And that's actually something that we talked about when we were starting to work on this. That's not something I had been doing, and I think that is something that is important, and that's something I'm going to start doing going forward.
Judge O'Hara?
Well, as we know under Apprendi, we've got to be careful about this issue. And so, although it doesn't happen often, when it does happen, you typically are dealing with a pretty seasoned defendant who knows how all of this works. Because typically, if they're stipulating in the aggravated range, they come with a little baggage to the courtroom. But I still go through and make sure they understand that they have a right to have a jury make that determination.
That's a good thing. Usually, that's what I usually do too. If you've got somebody who's got multiple cases and he's pleading in your case to an aggravated sentence, I usually tell them that they have a right to have a jury determine that, and by entering the plea, they're waiving or giving up that particular right. Judge Degenhardt, how do you address a defendant who's recently taken medication or consumed alcohol or drugs?
And that's one of I always ask if they have, if they've taken anything that would interfere with their ability to understand the proceedings that day. I have never had anybody indicate to me that they have until very recently. And he went through what he was on and that indicated that it wasn't going to interfere with his ability. I guess I would have to take that case by case to understand exactly what was going on with him, but it is something I always ask.
Judge O'Hara?
Certainly important to have the discussion. And sometimes people tell you I'm on this medication or that medication. I have them indicate what it is, have them tell me how that affects them. But if you do the job long enough, you're going to have a situation where you walk into the courtroom and you know somebody in here has been drinking. It's important to ferret that out.
I think so too. And the plea paperwork we have, there's a question if they've taken medication or drugs within 24 hours. And if they say yes, I then usually ask them when. I usually ask them what it is, and then I ask them if that would have any kind of negative effect on their ability to understand their lawyer, to understand me, to make a decision that day. So that's what I usually cover if they indicate that. But I think you're right. It needs to be covered if they're taking the plea. What about immigration issues, Judge Degenhardt? How do you address those, or do you?
I do address immigration issues. That's something else that's on our plea paperwork, is what their status is. And so depending upon what that indicates, we'll ask their attorney if they've gone over possible issues with them, and at least address that there may be negative implications by entering into the plea agreement that day.
Judge O'Hara?
It's a tricky issue because you don't want to just reserve the question for people you suspect might not be here legally. And I think a better practice is just include it in the advisement and ask everybody.
That's what I'd usually do. I usually ask if each lawyer, if they've been able to determine the immigration status of their client. And the trouble sometimes I have is when they say, my client is not a United States citizen. And then I think you have to go into a little more detail at that point in time. Would you agree with that, Judge Degenhardt?
I would.
What would you say to them at that point?
I don't have an answer for that. I'd be curious to see what you all, more seasoned attorney or judges do.
Judge O'Hara?
I try not to get too technical in the immigration consequences or what might happen to them, but I tell them, you need to know that as a result of you pleading guilty to this offense today, you could be excluded from this country.
That's usually what I do, is I tell them I'm not an immigration judge. I can't tell you what's going to happen. But the bottom line is the worst possible scenario is you could be removed from the country as a result of the plea here. And I want them to understand that and affirm that they still want to go ahead with the plea if, in fact, that's the situation.
Have you had their attorney then ask for a continuance so that they can inquire of immigration counsel?
That's happened, not a lot, but sometimes. And usually what it does is when we get to the point, usually it happens before the plea is taken. They tell me they need an extra time because they need to involve immigration counsel in order to address matters. And of course, I would let them be able to do that. And then when they come back, then they say on the record, we've spoken to attorney so-and-so and gone over immigration consequences. I don't inquire into the details of that because that's too Byzantine for me, but I try to make certain that they understand the bottom line being that they potentially could be removed from the country if they do that.
Sometimes the plea itself is an indication for us. So anytime you get trespass of agricultural lands as a reduction in the charged offense, it's a pretty good indication that's why.
And why is that?
Apparently, immigration attorneys have told criminal defense attorneys that that will not result in deportation.
So you know if that comes up, your radar is alerted at that point. Yeah. Do you inquire of the prosecutor with respect to his or her compliance with the Victims' Rights Act, Judge Degenhardt?
I do that. I like to have it on the record that there's been compliance.
Judge O'Hara?
Certainly, if it is a case that appears to be covered by the VRA, I will inquire of the DA if they don't tell me before we start, which they usually do.
Does your plea paperwork have a place on it for that indication, that checkoff box?
It does, and that's, again, one of those things where it's not always correct. And so just covering bases, I always try to ask as well.
So it's not checked, you'll ask them then if it's been gone over? Same thing with you, Judge O'Hara?
Yes.
And I wanted to go back briefly to that immigration issue. When you talked about it before, I do it with every person who stands up in front of me. That way it's clear that I'm not picking and choosing. I'm just doing it with every individual who appears.
Right, because that's just going to put you in quicksand.
Exactly. How do you address the elements of the crime? Do you cover the elements, or do you have the DA or the defense attorney cover the elements? Judge Degenhardt?
I normally recite it on the record from the plea paperwork. It's typically always indicated in the documents, and so I just recite it, ask the defendant if he understands or he or she understands that those are the elements of what they're pleading to.
Judge O'Hara?
So when there's a written plea agreement or written Rule 11 advisement, it's always covered in there, and I typically will rely on that language, and I will advise the defendant. Sometimes when there is a quick plea and we're doing an oral advisement, it depends on the prosecutor. If you know them to be sufficiently well-versed, they're perfectly capable of advising the person, but I often will just turn around and grab the jury instruction and tell them myself.
I usually rely on the prosecutor. Maybe that's a fault of mine, but I usually ask them to explain what the elements are. Then you kind of have to listen, because sometimes they kind of just gloss over that, and make certain that there's some kind of discussion about the culpable mental state and those kinds of things. But then I usually incorporate the fact that in writing, they've already gone over that too. So, but I usually let the prosecutor address the elements.
One thing that I would add on that is a lot of times for controlled substance offenses, they list a drug, ketamine, or whatever it might be.
Right.
Maybe something that's a pretend plea reduction. But I'll ask them, is there any question in your mind as to what that is? Instead of trying to read that whole Schedule 2 description.
Right. That's good. That's really good. How do you address the factual basis for the crime? Do you have the attorneys state that? How do you address whether there's a factual basis? Judge Degenhardt?
Sometimes attorneys state it, sometimes that as well might be in the plea agreement. They might have stated a basis in the agreement. And at times, depending upon what the agreement or the documents indicate, we'll ask if they waive or stipulate to the factual basis, depending upon the circumstances.
Judge O'Hara?
So if there's an arrest warrant or a warrantless arrest affidavit in the court file, I will have taken a look at that, and I'll just reference that I find from that document that there's a factual basis for the plea. Sometimes if there is a summons and there's nothing in the file about what really happened, I'll ask the prosecutor to lay a quick foundation for a factual basis.
And that's exactly what I do, is I kind of rely upon what's in the court file. If there's no affidavit in the court file, then I ask the prosecutor to state it, and then I usually ask the defense lawyer if he would agree that if that evidence were presented to a jury and believed by a jury, if it would be sufficient for them to return a verdict of guilty, and then they say yes, and then we kind of go from there. How do you make certain that the plea is voluntary? Judge Degenhardt? Any particular...
Just ask, is anyone forcing you to enter into this agreement? Are you doing this voluntarily? I don't know how, I guess you sort of pick up on body language sometimes where they kind of, again, have the deer in the headlights look, but I don't know how you can really gauge that, but just by asking.
Judge O'Hara?
I do the same thing. One of the pat questions I ask in every plea is whether anyone has pressured them in any way to enter a guilty plea today.
It's pretty interesting because I ask the same thing, and a lot of times you see the defendant almost like, no, there's been none of that. It's a nonverbal kind of thing that you see them do a lot of times. They're kind of almost surprised by the question, but I usually cover that with them before I take the plea.
It does make me nervous if they lean over to their attorney to ask what the right answer to that question is.
And occasionally that happens. How about making a record? Do you have anything you do at the end of the plea process to kind of tidy things up or wrap it up?
Not really. I ask both attorneys if there's anything else that we've not covered or anything that has been missed. I also ask my clerk often if there's anything that she needs in order to make sure that she has all the information she needs to
be
put it
inputted
into
on
the
the
record.
computer, yeah. Judge O'Hara?
I usually make specific findings about knowing involuntary waivers, understanding rights, and being represented by competent counsel.
At the end of our plea paperwork, they have that kind of criteria, and I usually just read those off and just say, I'm finding that the plea is being made today knowingly, intelligently, freely, and voluntarily, he understands his rights. And I just kind of go through that, but I think it's important to kind of state that on the record, because obviously it shows that you've been actually paying attention to the process, and that's what your conclusion is based upon watching the defendant. Is it important, you think, to have a formula or a pattern when taking a plea, Judge Degenhardt?
I do, because I think having a script to use so you don't miss anything and doing the same thing over and over, I think is useful, because hopefully that ensures that things aren't missed that need to be on the record.
Judge O'Hara?
I agree. I probably drive my court reporter crazy because you say the same thing over and over and over, but that the individual case is what's going to go up on appeal if something's wrong, not what you do to everyone else's case.
And I think obviously if you have a high volume day, sometimes we can have high volume days and you're taking 13, 15 pleas, yet it's good to be able to have something that's a formula that you just know in the back of your mind you're going to be able to cover. I want to talk just briefly about rejecting a plea. Do you have any thoughts about that, Judge Degenhardt?
I've not done it often, and I think it's always a little uncomfortable, what to say, because the few times I've done it, I always get the question back, well, what would you accept? And so just not getting into the plea negotiations, and so I think it's a delicate balance in terms of doing that. And it typically, I think, probably relates to sentence concessions and whether or not it's an appropriate plea agreement as far as the sentence concessions.
And I know, Judge O'Hara, you've thought about this a lot, so can you talk about that a little bit?
So when I first started, I think judges do this differently, and I'm not sure there's any one perfect answer. Sometimes we'll see a case that gets reduced from a Class 3 felony down to a Class 2 misdemeanor, and we're wondering what's going on. But like you said earlier, we don't always know what the lawyers know. We don't always know what's been going on behind the scenes. You might have a cooperating defendant who's provided some information to law enforcement. I think if the district attorney is changing the charge, that's a function of the executive branch, and they have the discretion to do that without interference from the bench. If it's a sentencing concession that we don't like, a deferred judgment, a stipulated sentence of some sort, a limitation of no prison or no community corrections, those are things that we can reject based on our view of the case.
I think that's a good analysis. Typically for me, the only time it really comes up is when I have a defendant, typically in a sexual assault case, saying, I'm pleading guilty, but I didn't commit this crime. And I usually tell them, I don't take guilty pleas from people who don't commit crime. And they have to kind of go back and refigure what they're going to do. But that's something that, for me, raises a red herring if they say, I didn't commit this. And I say, you need to stop and think about this before we go any further. Do you have any parting comments or anything else you want to say about this subject matter, Judge Degenhardt?
No, I think this is very useful, and I think it shows we all do things a little bit differently, but all kind of includes the same information, and I think having a script is really useful.
Judge O'Hara?
I think one suggestion might be for folks who are rotating into criminal for the first time or starting off as judges, make sure you're familiar with the Alford case and what Alford pleas are, and that this is acceptable. It's a hard thing to explain to people who aren't in our business, that people can plead guilty to the commission of a crime they clearly did not commit in order to avoid a more serious consequence. But it's going to happen in all of our courts.
That's a good point. I don't have anything else. I think you folks have covered it all, and I don't really have anything else to add. Thank you.